Hi, my name is Ida Shuri, and I'm a staff attorney with the HOCO work group. We are going to be presenting today on the Americans with Disabilities Act. Please note that nothing today is legal advice, and this is for your information only. So today, this is the agenda. We will be going over the Americans with Disabilities Act, public accommodations, reasonable accommodations, types of assistance, communicating with customers, service animals, wheelchairs and other mobility devices, structural barriers and accommodations, tax credits and deductions, and website accessibility. So first quiz time, our first Zoom question, I wanted to check in, who do you think is responsible for ADA compliance, the landlord or the tenant? So this is just the first question. So it depends on the lease. So it's important to check your lease before signing to see who is responsible for ADA compliance. It's going to be a combination of both the landlord and the tenant. Here, I just extracted a portion of the lease that talks about compliance. Here it's discussing that while the building may be said to be in compliance with the ADA law, any changes that tenant must make must also be in compliance with that law, and the tenant is responsible for those issues. So for example, you might be delivered an empty building and that might be compliant with the ADA. For example, it might have a wheelchair ramp and wide doorways. But if you start a restaurant and add furniture to the building, for instance, booths, and they impede that walkway, then that could be a violation of the ADA. So you have to make sure that any changes to the building still make it ADA compliant. But if there's an issue, for instance, with the original building, for instance, there isn't a wheelchair ramp on the outside of the building, that would be something that the landlord would be responsible for. But again, this is the situation for this lease. You want to check your own lease and note that there's certain requirements that are within the statute of the ADA, and the landlord can't necessarily waive their responsibilities just through a lease. So it's important to read your leases and what they state. So again, checking your lease, you'd also have a clause regarding whether or not the premises have been checked for compliance with the ADA. And here, the lease state it has not been checked. So you want to also review that and see whether or not you need to hire an inspector. So the American with Disabilities Act, the ADA, is a federal civil rights law that protects people with disabilities. This includes prohibiting the exclusion of people with disabilities from everyday activities like shopping at local businesses. In order to meet the goals of the ADA, the federal government has issued requirements for private businesses of all sizes and both profit and nonprofit. And under the ADA, disability means having a physical or mental impairment that substantially limits one or more major life activities like personal care, walking, seeing, etc. Having a record of such an impairment, such as a condition that's been in remission, or being regarded as having such an impairment. Two statutes in California, the UNRRA Act and the California Disabled Persons Act, incorporate the ADA into California civil rights law. They allow people with disabilities to sue a business to recover monetary damages. The UNRRA Act provides for statutory damages of $4,000 per offense. And the California Disabled Persons Act provides for statutory damages of $1,000 per offense. By contrast, Title III of the ADA, which is the federal law, provides only for injunctive relief. That means stopping a business from doing something or requiring them to do something against the violating business, rather than monetary damages. So in this way, the California laws are actually more expansive than the federal. The ADA establishes requirements for public accommodations, businesses that provide goods or services to the public. There's 12 categories of public accommodations. They include stores, restaurants, bars, theaters, hotels, museums, schools, medical offices, malls, and other types of businesses. Businesses that fall within the 12 categories will be subject to the requirements of the ADA, regardless of their size or age of the buildings. Commercial facilities that don't provide private goods or services directly to the public, like a factory or a warehouse, are only subject to the ADA's requirements in the instance of new construction or alterations to their buildings. To accommodate people with disabilities, your business may be required to make reasonable modifications to its rules or policies. Anything that would result in a fundamental alteration or a change that is essentially changes the nature of your business is not required. Again, they're supposed to be reasonable modifications. A reasonable modification would be something like when a restaurant maybe changes an ingredient in a dish. A restaurant is not required to prepare special dishes for customers who have disabilities, because this would be a fundamental alteration in the nature of the restaurant's services. But if it's easy to omit a sauce or ingredient from a dish that's listed on the menu, a customer can request that the item be omitted. This won't be considered a fundamental alteration. Another reasonable modification would be a daycare center that allows a child with diabetes to have an extra snack. For another reasonable modification would be a clothing store allowing 2 people in a dressing room if that person with disabilities requires someone else in there. But the clothing store doesn't have to provide assistance with the person to dress if that service is not offered to other customers. And customers with disabilities may need different types of assistance to access your business's goods or services. For example, they might need help retrieving merchandise from high shelves. They might need assistance navigating the aisles of a store. They might need assistance in reading product labels and instructions. Businesses have to take steps to communicate effectively with customers with vision, hearing, and speech disabilities. The method of communication can vary depending on the abilities of the customers and the complexity of the communications that are required. For instance, someone might have varying levels of hearing disability, thus requiring different levels of assistance. An example, a sales clerk may exchange written notes with a person who is deaf. However, a sign language interpreter might be needed to discuss cancer treatment options. Quiz time. Is an emotional therapy dog protected under the ADA? So comfort therapy or emotional support dogs are actually not protected under the ADA. However, service dogs are. And a blanket policy not allowing pets from entering your business may run afoul of the ADA with respect to persons who rely on service animals for support. A service animal is a dog that is individually trained to do work or perform tasks for an individual with a disability. However, a comfort, therapy, or emotional support animal are not service animals under the ADA and are not protected under the ADA. Service animals must be harnessed, leashed, or tethered unless these devices interfere with the animal's work or the individual's disability prevents him or her from using these devices. Individuals who cannot use such devices must maintain control of the animal through voice, signal, or other effective controls. Businesses may exclude service animals only if, one, the dog is out of control and the handler cannot or does not regain control, or the dog is not housebroken. If a service animal is excluded, the individual must be allowed to enter the business without the service animal. If it is not clear whether the dog is a service animal, a business may ask only two questions. One, is the animal required because of a disability? Or two, what work or task has the animal been trained to perform? Businesses, wheelchairs, and other mobility devices. Businesses cannot prevent people with disabilities from using mobility devices in all areas that customers may enter. This may include other mobility devices such as segways and golf carts, depending on the establishment's ability to reasonably accommodate such a mobility device, given the device's size, weight, speed, and other concerns. Also, you must allow the customer to enter with a device unless the business owner can demonstrate legitimate safety requirements that prevent the customer from safely entering, not based on speculation or stereotypes. So businesses may ask individuals using an alternative mobility device, like a Segway, for credible assurance that the device is required because of a disability. Such proof may include a disability placard or verbal affirmation. Note, a business should not try to question the nature of a customer's disability. Architectural barriers. Architectural barriers are physical features that limit or prevent people with disabilities from obtaining the goods or services that are offered. This can include parking spaces, entrance steps, door handles, aisles, counters, and tables. The ADA requires that small businesses remove architectural barriers in existing facilities when it is readily achievable to do so. Readily achievable means easily accomplishable without much difficulty or expense. This requirement is based on the size and resources of a business, as well as broader trends such as the economy. The ADA standards for accessible design can be a helpful resource for determining when removal of an architectural barrier may be required. When a business removes barriers, it should follow the design requirements for new construction in the ADA standards for accessible design. In some cases, existing conditions, limited resources, or both will make it not readily achievable to follow the standards fully. If this occurs, barrier removal measures may deviate from the standards so long as those measures don't pose a significant risk to the health or safety of people with disabilities or other people. So if you're unable to achieve the standards, you can use alternative methods as long as they aren't posing a risk to other people. But you must do things within your financial ability. The ADA regulations recommend the following priorities for barrier removal. So when you're trying to prioritize what's financially feasible to alter in your business, look at these specific goals. Providing access to your business from public sidewalks, public parking areas, and public transportation. Providing access to the goods and services your business offers, like for instance, accessible shelves, things like that. Providing access to public restrooms, and removing barriers to other amenities offered to the public, such as drinking fountains. Where even a single step prevents people with disabilities from entering your business, installing a ramp or a lift or regrading the walkway can provide an accessible route. If the main entrance cannot be made accessible, an alternate accessible entrance can be used. Accessible routes. So the path a person with a disability takes to enter and move through your business is called an accessible route. This route, which must be at least 3 feet wide, must remain accessible and not be blocked by items such as vending or ice machines, newspaper machines, furniture, or filing cabinets. Shelves and counters must be on an accessible route with enough space to allow customers using mobility devices to access merchandise. So as you can see in the photos here, these would not be accessible routes because the first photo you have a pole impeding the right of way. The second photo, there is a single step that impedes the person from walking across this crosswalk after the wheelchair ramp. And the third one, the ramp does not go to an entrance. And it includes steps as well at the bottom. So where barriers prevent access to these areas, they must be removed if readily achievable. However, businesses are not required to take any steps that result in a significant loss of selling space. So you can see that small ramp that is provided for the single step right there in front of the door. People with disabilities need to access tables, food service lines, and condiment and beverage bars in food service establishments. They have to have an accessible route to all dining areas, including raised or sunken dining areas, outdoor dining areas, and food service lines, counters, and public restrooms. Businesses must provide accessible parking spaces for cars and vans if it is, again, readily achievable to do so. 1 of every 6 parking spaces must be accessible by a van. Small businesses with 4 or fewer parking spaces must have 1 accessible parking space, but it's not required that you have a sign. An accessible parking space must have an access aisle to allow a person using a wheelchair or other mobility device to get in and out of the car or van. So, existing facilities safe harbor. So if you were in compliance with the 1991 standards for the ADA, you do not have to modify further your building for the 2010 standards, even if the new standards have different requirements for them. But if you choose to alter your building in any way, then you are required to be in compliance with the 2010 standards. So that is what is a safe harbor in this instance. However, if there's new requirements that didn't exist in 1991, you have to implement those new requirements. New construction and alterations. If a business alters any of its facilities, it must make that alteration accessible to the extent that that is feasible. An alteration can include remodeling, renovating, rehabilitating, reconstructing, changing or rearranging parts or elements, or the reconfiguration of walls or heights of walls, etc., that can affect the usability of the facility. Normal maintenance, such as re-roofing, painting, putting up wallpaper, that's not considered an alteration. State building codes. So whenever there's a construction or renovation, there's the requirement to make improvements. So all newly renovated areas have to meet accessibility standards. And businesses may also be required to ensure accessibility of the building's main entrance, the route to the renovated areas and bathrooms, drinking fountains, etc. If the cost of construction is under the threshold of state valuation, you can limit the cost of accessibility improvements outside the area of remodel to 20% of overall construction costs. Building inspectors will check whether the renovations covered by your building permit meet the accessibility requirements under the building code. However, your entire business location must still comply with the ADA barrier removable requirements. So a professional certified access specialist can inspect your location and provide a written evaluation that certifies that your business is compliant with state and federal disability access laws. If your business is not in compliance, they will also provide a report explaining the steps to achieve full compliance. So this was something that we referred to earlier when looking at the lease. So again, looking at that lease again, they had checked that this inspector had not inspected the property. So if you wanted to, you could request an inspection and the other boxes would be checked. To assist businesses with complying with the ADA, Section 44 of the IRS Code allows tax credits for small businesses and a tax deduction in Section 190 for all businesses. So there is a tax credit for small businesses who make less than $1 million or have 30 or fewer full-time employees, and you can get a maximum credit of $5,000. You can also get a tax deduction that's available to all businesses. That's up to $15,000 per year. And these credits and deductions are going towards the expenses incurred to remove barriers and make alterations in order to have your business comply with the ADA. The Department of Justice has not released regulations outlining the requirements for website accessibility, but it's indicated that they do apply to business websites. So you may look into captioning your videos and images, as well as information, such as a webinar presentation such as this, and make those also available as PDFs. And those can be accessed by a person with low vision or someone who's using an assistive technology device. So these are different websites that provide information for you. You can go to the ADA's website. There's also an information hotline to discuss the requirements of the ADA. And there's also regional networks that provide technical assistance. There's also technical assistance at the Access Board and the EEOC, and they also provide information to employers regarding the ADA. The Small Business Administration is also a resource. This is our last quiz of the day. Have you checked your lease to see who is responsible for ADA compliance? Okay, great. Well, I did want to let everybody know that our nonprofit does provide assistance to small businesses. And if you do need assistance, you can go to lalegalhelp.com and fill out the form there, and you will be connected to a nonprofit, either us or another nonprofit that we work with that will provide assistance to you, and we can help you read your lease and let you know what kind of legal requirements you are bound by. So at this moment, we will take any questions. If anybody has any questions regarding what was presented, we can't take any questions that are personal to you. But if you do have a personal question regarding anything that you are going through in your business, we can always get your information and set up a phone intake later on. So did anybody have any questions? You can feel free to type them in the chat right now.
I was just curious. I've been to a number of events recently, and have, seen some things on social media where there is an ASL interpreter who is present to assist the hearing impaired. And I have a question about what is the obligation that venues have to provide an ASL interpreter in those types of circumstances? Is it something that's automatically required under the ADA, or is it something that the patron needs to notify the venue? Including in government settings.
Sure. So I think it goes back to the whole reasonable and for instance, if something is affordable and it's going to be contextual. There's not going to be an across the board answer. For instance, if you are having a webinar, but you have things accessible, for instance, through PDF or other measures, then an ASL interpreter might not be necessary because they can read the slides or other text. However, if you have maybe a presentation or announcement, like Karen Bass is announcing something, and there is no, it's live and there's no other closed captioning provided or something like that, or a concert that has no closed captioning, then one might want to provide an ASL interpreter. So it's really contextual. I wouldn't say that there's a across the board answer regarding that. And again, it's also related to what's financially feasible for your business. So if you have a small business and you're doing like a small intimate workshop, most likely you're not going to be required to have an ASL interpreter because the cost of it could be as much as the workshop itself. But you might want to provide written materials to be compliant with the ADA and something like that to allow people with disabilities to still participate. I hope that answered your question. Feel free to let me know if you have any other follow-ups. So, Christy, do we have any resources to make websites ADA compliant? So I don't have any resources off the bat. I would look at those resources that were in the PowerPoint. And again, I would say there's usually some resources within website service providers in terms of providing alternate text to images or providing text for things that have audio. And I would work with the website provider for those things, but I don't have any resources per se for like a company or anything like that. Because again, it's going to be really dependent on what the website looks like, but usually there's resources within those website providers as well. Did anybody have any other questions? Okay. We do not have recommendations for actual vendors. I would contact those websites that were in the resources section. They might have listings. No, we don't have a recommendation for actual vendors. Were there any other questions? Well, again, feel free to go to lalegalhelp.com and we can provide any more answers to your questions. We're happy that you all joined us, and I hope everybody has a great evening.